Good afternoon. Appreciate everyone's patience. Let me get the agenda. Ed, you sent an updated one, I believe, right?
Yes, do you want a paper copy?
Yes, please. Oh, appreciate that. Welcome, and I guess I'll call this meeting to order. I guess first on our list is the, approval of the August agenda.
I think the only change on the agenda would be that we don't have Dr. Pagano here for introductions. He had a work conflict, so he's unable to attend today.
Yes, the next item on the agenda is the approval of the August meeting. Apologies again. What's the appropriate verbiage, I should say, to call for the approval?
Just approval of the minutes, unless there's any changes.
You want to second it? Yeah, thank you. I guess the August agenda was approved. Next is public comments. Is there, nobody is here for public comment? And Dr. Pagano is unfortunately not here, so next on the agenda is the consent decree update. Ed?
Yes, good afternoon. Is it this week Monday already, or it was last week Monday? Sorry, this is only Tuesday. Last week Monday, the selection committee introduced its two finalists to be the independent monitor under the community commitment agreement with the administration and the chief of police. The two finalists are 21st Century Policing Solutions and Effective Law Enforcement for Everyone. Quite a contrast in styles, I would say. 21st Century Policing has, their heads are former Department of Justice attorneys, civil rights attorneys, and there's also Chief Ramsey from Philadelphia and DC. Two or three of the members of 21st Century Policing Solutions were authors of President Obama's 21st Century Policing Plan. I would describe them as the more corporate of the two teams. They also pledged that if they were selected as the monitoring team, they would be hiring two local persons to be a part of the monitoring team. Effective Law Enforcement for Everyone did not make the same pledge. They said that they would have their team intact. Their team is from New Orleans and Baltimore. They appear to be more community-oriented and more grassroots. With experience, they are the monitoring team that is currently in Minneapolis working on their consent decree. There were questions from the audience. There was actually a specific question regarding working with the Inspector General's office. They both pledged to work with the IG's office and to make sure that we had the resources that were necessary and that we were an intricate part of the community commitment. They understood that we had a separate role from the Community Safety Commission. I'm confident that both of the teams will do a good job as being a monitor. They both do have monitoring experience. And I would anticipate that probably within the next week or 10 days, the selection committee will render its decision, and then they will go about putting together the agreement for monitoring. So, any questions regarding that? If you want to watch if you want to watch that particular community meeting, it is available on YouTube. It will last about an hour and 15 minutes. However, the comment period for the selection has passed. That closed on Thursday.
from my perspective. I watched the video. I couldn't attend in person. But anyway, so the question I do have, do you know how would the monitor work? I know it's laid out, but from your perspective, do you know how they would work with the Community Safety Commission board? Just based off of their answers, I didn't realize like the monitors wouldn't be here, and then like they're actually working and implementing with multiple cities. So do you know how that would work?
Yeah, what they'll do is they'll do site visits, and they'll come in, and at the beginning of the monitoring period, those will be more frequent because they'll be offering technical assistance at that point, and they'll be putting in place the parameters for monitoring the behavior under the paragraphs of the community commitment. And then effective law enforcement for everyone committed to quarterly reports. 21st Century Policing did not commit to a specific reporting period, but their reports are going to go to the Community Safety Commission, and that's where that's going to be reported out. And then once that report goes out to the Community Safety Commission, then that will be disseminated publicly. There are some questions about whether or not the department will have the opportunity to comment on the draft report prior to it being released publicly. I don't know what these particular monitoring teams' practice is. I know that in my experience, the monitoring team does allow the department to comment on their findings in case there's some error in the report to help the monitor before it is disseminated publicly. It won't go to the point of being able to change a decision or change an assessment, but it can add context and can add for further explanation, which is provided in the report. But that's up to the monitor, and that's also probably going to be negotiated in the monitoring agreement as that gets set forth. So while 21st Century Policing says that they'll have 2 people, local people on site, effective law enforcement said that they will not. So essentially, there'll be site visits where the entire team is here. They're meeting with all of the parties necessary, so they'll meet with the chief's office. They'll meet with perhaps the crimes against children, or they'll meet with domestic violence, or they'll meet with Major Wampler's PSU unit regarding those particular areas, so misconduct or however it's outlined. And they'll meet with them individually to gather data in order to make their assessment based upon the behaviors as outlined in the paragraphs.
Did anyone question why they decided not to have the other company decided not to have any locals on site?
Yes, that question did come up, and effective law enforcement said that they didn't need someone on site, that they believed that they would be here enough and have enough contacts in order to do the job adequately.
They made to your point, they made a lot of comments about their technical experience and what they would be bringing. What does that essentially mean? Because I didn't hear them go into depths. Is that more so streamlining to make sure they have more data visible to civilians, making it easier for people to submit complaints, digitizing a lot of things? Do you know what that looks like from 21CP, from previous stuff?
Well, I think the technical assistance, first phase of it will be analyzing the policy changes that the department envisions are adequate at this point. So the department has made policy changes that they believe will comport with the community commitment. So the first phase will be analyzing those policies, and they may offer assistance where they believe those policies may fall short. That will be the first phase. And then the second phase will be the data collection for evaluating the performance. Also, the training. So there will be the policy, then there will be the training, and then there will be the behavior. So policy first, advising on the policy, making sure that those are adequate, and then looking to make sure that the department personnel are trained in that policy, and then how do those policy changes affect the behavior of the department?
Do you think, is there opportunity for them to go in depth in the sense of like audit testing it? So, I mean, they can see that the policy is designed reasonably, but is it operating effectively? Are they going to see, does it tie to like different processes, procedures that the actual officers go to and like look at previous cases?
Yes. Yep.
And based on your experience, the lack of having locals involvement, does that concern you? Is that consistent with your experience dealing with other such groups?
My previous experience is that the monitoring team does not have local presence initially. That in Albuquerque, that actually evolved because the department had problems with its force investigation unit. And so short of Albuquerque being found in contempt of the consent decree, they entered into an agreement to have an external consulting team come in that was on site 24/7 to do use of force investigations. So initially, no, there wasn't anyone there, but it became necessary. It's really kind of the preference of the team. I know that two of the teams that didn't make the finals were looking for local people to be a part of their team. But then there would be the argument from some within the community, well, you know, if you have local people here, then you're too immersed in the system. So, you know, it kind of goes both ways. And so, quite frankly, most of the time, the bulk of the monitoring team is not from the local community.
Any other questions, Fred?
What's the term of the monitor initially?
The initial plan is for 5 years, and the first contract is for 1 year for the outlined funds appropriated, the $750,000 in the contract. And then it will be up to the monitor to come back to the administration to say, this is going to be the price tag moving forward year to year. The plan envisions that this should be completed within 5 years. There is, I believe that there's a 2-year reassessment built into the commitment, but I'd have to go back and look at that. But I think at a minimum, 5 years.
As a follow-up to that, is that normal? Is it normally a 1 to 2 or 1 to 5 year, based on your experience?
I think that 5 years is aggressive if you're going to change the culture as envisioned in the community commitment. But we will have to see. It's a goal, and but I think that 5 years is aggressive. Certainly, it's one of the complaints that you will see, that these take too long. These consent decrees or types of consent decrees, but no one's done it in less than 8 to 10 years.
I'm having a little problem processing that, because you're using the word aggressive, and I'm taking that as actually a good thing. Is that how you meant that?
I'm aggressive as believing that everything can be accomplished in 5 years, and that there can be sustained compliance over that period of time. And proof, right. Right.
Thank you.
So in that first year, is the monitor actually administering the training that you're talking about, or is that going to be a completely different entity?
No, the monitor will not conduct any training but for technical assistance to the particular areas of command that they're dealing with. Actual officer training will be the responsibility of the department.
And the $750,000, that's just for the first year?
Correct. for the monitoring team. So the monitoring team is probably going to be at 8 to 10 people, because you're going to have misconduct experts, use of force experts, community policing experts, mental health crisis experts, all part of the team that come in. And then you will have a monitor and a deputy monitor overseeing the entire team.
The thought process is that this is penny wise as opposed to nothing, which would be pound foolish, and that by paying $750,000, we're not continuing to pay out every year $4, $6, $8 million because of problems. Well, there's systemic problems that our department has faced over the last few years.
Absolutely. I think that despite what you might read in reports, I think that monitors pay for themselves by the reduced civil liability and civil exposure.
And I'm sorry to do follow-up questions. It's just I'm no longer practicing law, and so maybe this is my only time to do that. Have there been studies that show the effectiveness of these kind of resources being applied and how they've saved money, how they've done all that? And you were going to say that.
Well, I mean, I was going to say that's what the monitor teams, when they came, that's what they're campaigning off of, especially 21CP. They're talking about what they've done. Almost think of it as like a solution. They're bringing it. It's like, hey, we put in this SaaS solution, IT background, but SaaS solution at this place, it worked well, and now we're going to bring it here, and we're just going to drop it off. We're going to train the people on it somewhat, but we're not sticking around to see the results. And to Ed's point, yeah, I agree. It's like, we can do all of this in 5 years.
And I apologize because I didn't get to watch that because of something else, but that makes perfect sense.
No, it's a question that comes to every community that faces this crossroad, because you will have many who get sticker shock for what they see, and but the untold story is the millions of dollars of civil payments that have gone out. And if you prevent one per year, then your monitor is paid for.
I think I mentioned this at my last meeting. This hopefully will be my last comment on this line. But we've paid out something close to $40 million over the last 3 or 4 years.
Something like that. And there's still some high price tag incidents out there, yes.
And the highest police department payment is Chicago at $400 million.
That I don't know.
I was just playing around on AI. That's what and they're 10 times larger than we are. So we're paying about the same level as Chicago, applying that analysis. And guys, everybody here knows AI gives us a direction. It really doesn't give us final answers because it's not sophisticated enough.
Yeah.
So you're understanding that it's...
Yes.
Any other questions? Appreciate that update, Ed. I guess we can start with the investigation recommendations.
Okay. Moving on to investigation recommendations. The first case, 153 IG-2025. The subject of the complaint is a wrongful arrest allegation. The complainant, let me back up. So our recommendation is, due to a pending professional standards unit investigation, as well as the complainant's retention of legal counsel, our office recommends no further Office of Inspector General investigation into the events in question at this time. Once the PSU concludes its inquiry, our office will review the completed case file in its entirety before determining whether additional review or administrative action is warranted. The complainant states he was wrongfully arrested on a warrant from LMPD. The charges were later dismissed after spending 5.5 months in jail. He further states his arrest was on Christmas Eve in front of his children, causing emotional distress and family trauma. He missed the birth of his child while incarcerated. During his 5.5 months in custody, he relied on financial support from family members, creating economic hardship. The extended detention caused emotional, financial, and reputational harm. I should further state that the complainant came to us based upon the referral from the public defender's office. His public defender referred him to us. The preliminary investigation conducted by our office. On 1/15 of 2023, LMPD officers responded to a shot spotter activation. While en route, the Real-Time Crime Center provided an update that a male subject was observed pointing a firearm at a female and discharging a round into the air. On arrival, officers observed an open front door and made contact with the victim. The victim disclosed that the subject, described as an intimate partner, became angry during a verbal exchange, struck her twice with a closed hand, and tore her shirt during the scuffle. Victim further reported the suspect discharged a firearm, but could not confirm if the shot was fired into the air or in her direction. Officers documented visible injuries, completed a lethality assessment, collected a 9mm shell casing outside the residence, and advised the victim of her rights and the emergency protective order process. Victim provided limited information identifying the suspect only as Mikey, approximately 24 years old with a beard. On January 17th of 2023, the case was assigned to a detective in the domestic violence unit. On the 18th of January 2023, the detective identified a Michael Anderson matching the victim's description. A photo was obtained for the victim's confirmation. The victim did not initially answer, but later returned the call to the detective and directed the detective to the suspect's YouTube page. Based on this information, the detective positively identified the suspect and secured an e-warrant for Michael Anderson. Move forward to 2024. On 12/24 of 24, the complainant, Michael Anderson, was arrested by Jefferson Police Department on the e-warrant and booked into LMDC. On February 10th of 2025, the complainant was arraigned. On April 23rd of 2025, the pretrial conference was scheduled. In May of 2025, the Commonwealth's attorney received communication from the complainant's attorney raising concerns about the identity of the individual named in the warrant. On the 6th of May, the Assistant Commonwealth's Attorney Grossman contacted the domestic violence detective, who acknowledged that incorrect descriptors from a separate Michael Anderson's CourtNet file may have inadvertently been included in the arrest warrant. Mr. Grossman confirmed the case would be dismissed. The domestic violence detective informed the chief's legal counsel, Lisa Jarrett, of the matter on May 6th of 2025. The domestic violence detective later memorialized this acknowledgement in an email to the county attorney's office, admitting the, quote, inadvertent error in the suspect's identifiers. May 16th of 2025, the case was dismissed, and on the 20th of June 2025, the complainant filed a complaint with our office alleging wrongful arrest and unlawful incarceration. Analysis. The facts are clear. The complainant was unlawfully seized in violation of his Fourth Amendment rights. This case contained systematic failures throughout the Jefferson County legal system. The Office of Inspector General's jurisdiction is limited to the actions of LMPD. Based upon this preliminary investigation, those areas include, but are not limited to, the flawed investigation by the detective in the DV unit, the inadequate supervision of the detective at the unit and the command level, the DV unit practices and protocols. The PSU investigation into this matter only began after the Office of Inspector General began its preliminary investigation, and not after the admitted mistake or the notification to the Chief's Counsel by the detective. Our further recommendations are: LMPD immediately review all open warrants sworn to and obtained by the detective in the domestic violence unit. No further investigation by our office at this time, given the active PSU investigation and the ongoing legal representation of the complainant. We also recommend that OIG conduct a post-PSU review. Upon completion of the PSU findings, the PSU will turn over the entire original case file, including but not limited to investigative reports, warrant documentation, and administrative communication. And we are also recommending preservation of all records related to this investigation, including but not limited to body-worn camera footage, RTCC recordings, warrant applications, CourtNet search history, and internal communications. Those should all be preserved in anticipation of further review. I stand for questions.
I have a question. If the PSU investigation is completed before the civil litigation or anticipated civil litigation against Louisville Metro and other parties is still ongoing, will your office delay its investigation until the civil case is resolved, or will they be going on parallel tracks?
I think we'll have to kind of cross that bridge when we come to it. I would see no reason why we couldn't do our review, even if there was pending civil litigation, because our findings, well, it's unknown what the admissibility of those findings would be related to the civil litigation. Certainly if it was a criminal matter, then we would wait until the criminal matter was completed. But we'll have to see where we are when PSU completes its investigation.
When PSU finishes their investigation, you guys are freely to reanalyze this case?
I'm sorry?
Once PSU finishes their investigation, like within your guys' process, you guys are free to reanalyze this case?
We'll take a look at the whole thing, absolutely. There's many, at this point it appears there's many layers to issues within the department itself. And I think, as we stated, there's systematic errors here that involving the court system as well, but those aren't things that we have jurisdiction with. But we will want to take a look at the entire PSU investigation to ensure its comprehensiveness.
Again, as I'm a new member, have there been problems in similar cases in receiving the wide breadth of information you are seeking, or do you feel that you will receive all that information?
Well, we have taken, I guess you could call it the extraordinary step of saying that we want the original file in this case, not selected copies from the file. We want to see the complete original file for our review.
And obviously, my follow-up question is, why that selective language? But I think I'll just pass and just accept on.
I think I'm going back to law school. Res ipsa loquitur. It's apparent on the face.
Thank you.
My last question, so I just want to make it clear, so they were like wrongfully arrested and in a jail cell for 5.5 months? Or is the total, okay.
Yes. He was arrested on the 24th of December and released on the 16th of May.
Detective memorialized. What do you mean by that?
There's case notes.
Okay. Yeah, I mean, I know situations like this happen. It's just more so baffling when you hear it and everything you guys wrote down in the investigation. Interested to see Chief Humphrey's response to this. But is there any other questions?
I would ask for a motion to approve our recommendations.
Second.
All right.
Did we have the vote?
Sorry. All those in favor say aye.
Aye.
All those nay?
Thank you. Next on the agenda is 158 IG 2025. The date of the incident is the 1st of October of 2022, and we received the complaint on the 23rd of July 2025. And the complainant alleges that she's been harassed since October of 2022. And in this case, we reviewed LMPD reports, computer-aided dispatch reports, and interviewed the complainant. We completed our review, and we're recommending no further investigation at this time. Preliminary investigation revealed through the complainant's interview that the complainant believes she's being harassed by members of LMPD because she overheard a member of LMPD talking about her on the phone in a Family Dollar store. Complainant could not provide the officer's name or any identifying information. Complainant also believes that members of LMPD are helping her neighbors harass her, but could not provide any specific incidents of harassment or officer involvement. Complainant was unable to provide names of officers that she believes are involved and was unable to provide names of her neighbors or who she believes are harassing her with the help of LMPD. Office of Inspector General's staff submitted an OIG information request to LMPD related to the complainant and reviewed several calls for service made by the complainant, none of which resulted in any actions taken by LMPD. Complainant was unable to provide any information related to incidents involving members of LMPD that support her allegations of harassment. Therefore, the Office of Inspector General is recommending no full investigation because the complainant could not provide any substantial information to support her allegations. And I stand for questions.
When you noted that she made, the complainant made several calls for service, what does that all entail? She called police for help?
Correct.
And there was no responses?
The police responded, but they didn't take any action. They didn't take any negative action toward her.
Any other questions? No. All right. Motion to approve? All those in favor?
Aye.
All those names?
Thank you. Next is 161 IG-2025. The date of the incident and the complaint are 7/25 of 2025. Complainant alleges that her residential property, a stone retaining wall, fence, and light posts were damaged in a hit-and-run incident that occurred July 17th of 2025. Complainant further alleges that members of LMPD failed to investigate the incident or press charges on the driver for leaving the scene of the accident. Complainant further alleges that the LMPD officer assigned to the case did not act in a professional manner or show general courtesy to her when dealing with the incident. In this matter, we reviewed the body-worn camera, we reviewed the LMPD reports, we reviewed the computer-aided dispatch reports, and also interviewed the complainant. We're recommending no further investigation. Preliminary investigation revealed the complainant reported a hit-and-run incident that damaged her residential property on July 17th of 2025. Complainant's privacy fence, stone, retaining wall, and light posts were damaged. The driver left the scene. Pieces of the car that fell off as a result of the accident were left in the complainant's yard. Complainant located the vehicle and made contact with the driver. Complainant located the vehicle and made contact with the driver and provided the information to LMP. The driver contacted LMPD on July 18th of 2025 to report the incident. LMPD officers spoke to the driver and the driver's grandmother. The driver provided the officers with proof of valid insurance. The LMPD officer assigned to the case used officer discretion and chose not to charge the driver with leaving the scene of an accident because she self-reported the incident the following day and she provided proof of valid insurance. The OIG investigator reviewed the LMPD officer's body camera and did not see any evidence that the officer acted in an unprofessional manner and did use courtesy when speaking with the complainant. OIG investigator reviewed all relevant case files, body-worn camera photos, and found that LMPD acted within policy. Therefore, we are recommending no further investigation.
Motion to approve.
I have a question. I'm surprised that there's discretion in bringing a charge for leaving the scene of an accident if someone self-reports it the next day. You can imagine a scenario where a driver is intoxicated or under the influence of something. They do damage, they're in a wreck or whatever, they flee the scene the next day, sober, they report the incident and give a report and all that. I understand there may be underlying circumstances here that would warrant not bringing the charge because of just the totality of circumstances, but I'm really surprised at that. But is that policy?
Yes. It is, yeah. Yeah, it is one of the surprising aspects that there's discretion. But I guess perhaps it's an incentive for someone to actually report, as opposed to if there was no discretion, then there's no incentive to report the next day or later.
That part of your car in the victim's yard probably would track you down. Plus, the complainant had already made contact with the driver, so
Yeah.
the driver knew
Yeah.
they were going to be talking to law enforcement, right?
Yeah.
But yeah, I see. Hey, interesting.
Motion to approve.
All those in favor?
Aye.
All those nay? Thanks, Ed.
Okay, next is 165 IG 2025. The date of the incident is the 4th of March of 2025, and we received the complaint on the 4th of September. Complainant reports having issues with her ex and brother. Complainant reports not being able to trust people and being drained mentally. In this case, we were only able to review the ordinance. There wasn't any body camera, LMPD reports, or CAD, computer-aided dispatch, to review. But speaking with the complainant does not allege any misconduct committed by members of LMPD, so we're recommending no further investigation.
Second.
And 168 IG-2025. Date of the incident was August 2nd of 2023, and we received the complaint on September 16th of 2025. Complainant alleges misconduct of the Indian Hill Police Department. We're recommending no further investigation because we don't have jurisdiction over this department.
What was the nature of the misconduct alleged?
I don't know that I have that in front of me.
If you don't mind, I'm not seeing a copy of whatever it was they complained about.
See. Okay, let me make a note. Okay, I'll send that out. So that ends investigation recommendations. We move on to investigation findings, 72 IG-2024. This report presents the findings of the Office of Inspector General regarding allegations of misconduct by Officer Jason Woods. The investigation was initiated following a complaint submitted by the complainant and alleges allegations of abuse of police authority, sex misconduct, and policy violations. The investigation reviewed interviews, digital records, internal records, and departmental policies to assess the validity of the claims. On January 24th of 2024, the Office of Inspector General received a complaint alleging misconduct by Officer Woods. The complaint was approved for full investigation by the Civilian Review and Accountability Board on June 26th of 2024. The allegations included inappropriate relationship, misuse of law enforcement resources, and false statements. The allegations are as follows: inappropriate relationship with a convicted felon, use of CourtNet to access criminal records without a lawful purpose, false statements in an emergency protective order affidavit, sexual activity while on duty, threats made to the complainant, and the officer's involvement in a federal case involving a different female with whom Officer Woods had a personal relationship. The investigation included review of the complainant and witness interviews, phone and text message records, court documents and EPO filings, internal reports from both the PSU unit and the PIU unit, departmental SOP and firearms records, social media and digital communications, communication logs between Officer Woods and the complainant, transcripts of interviews with the involved parties, firearms discharge records and SOP compliance, CourtNet access audit attempts, statements from probation and parole, and letters written by the officer on behalf of the second female in the allegations. As a part of this review, we reviewed LMPD SOP 4.13.14 discharge of firearms, 5.1.47 recusal, 5.1.22 sexual activity, 5.1.2, obedience to rules and regulations. 5.1.12, associations with persons of questionable character. And 5.1.8, police business confidential. Findings. The investigation found no evidence supporting the officer knew that the complainant's felony status prior to the events of August 3rd, 2023, which was their meeting date. The officer terminated the relationship with the complainant as directed by the command staff. Reporting the discharge of an unauthorized firearm is not required by is not required per policy. Further, the investigation also shows the officer accessed CourtNet to verify the complainant's criminal status, that the officer filed an EPO with statements that were later verified as true. The allegations of sexual activity while on duty could not be substantiated. There was little or no investigation into the threats of personal harm to the complainant. But we did find that Officer Woods made false statements during his PSU interview when he stated he did not have any contact with the defense in a federal case involving the second female in this case, when in fact evidence shows the officer had contact with the defense in a federal case involving that particular female. Several discrepancies were noted. PSU reported no texts from Woods to the complainant during a specific time period, but phone records show 32 messages were sent by the officer to the complainant. PSU did not interview a second officer who could have been a witness or pursue a CourtNet audit to address Officer Woods' misuse of department resources. In an attempt to try and get the audit, we contacted the Metro Council Government Oversight and Audit Committee in an attempt to obtain a subpoena, but the Metro Council Subcommittee did not respond to our request. PSU did not fully explore the complainant's knowledge of Woods' duty status or question her interactions with the complainant, and there are also conflicting statements regarding Officer Woods' involvement in the federal case. While many allegations were not sustained or were exonerated, the investigation revealed procedural inconsistencies, communication discrepancies, and potential integrity concerns. The findings warrant administrative review and policy reinforcement. It is our recommendation that PSU case 24-018 be reviewed for potential false statements by Officer Woods, that the department clarify policy on relationships with individuals involved in criminal proceedings, that it reinforce training on firearm discharges, reporting, and SOP compliance, and that it audit PSU investigative practices for thoroughness and consistency. I stand for questions.
Looks like no questions.
Can I, Mr. Inspector, can you explain or elaborate a little bit more on what you mean in terms of recommendations on number 3 and number 4? Like how wide on the audit and what you mean by reinforce the training there?
Well, there was a firearm discharge that took place that I believe. I'm sorry? Okay. Yeah, there was a firearm discharge in the officer's home that did not involve the service weapon. So therefore, it was not a mandatory reporting by policy.
Is there an explanation why it would be?
A policy deficiency.
And there were several discrepancies were noted. PS reported no text from Woods to not. during a specific period, but phone records show 32 messages were sent by Officer Woods to Ms. Knott. Can you elaborate on that for me?
I think that that's just what that's what our findings are, which is a discrepancy from what's in the PSU file.
And again, because I'm new and I don't know how far you all can go, where you and PSU provided the exact same information and looked at this exact same information to find these two separate conclusions?
I believe this information would come right from the PSU file, correct? Yes, it came from the PSU file.
And not to,
This was not a situation, as you're asking, did we get this directly from the complainant and it was not a part of the investigative file? This is only our review of the investigative file for PSU.
Do you have any explanation to us as to that discrepancy?
No.
PSU question.
That's why we were recommending a review of the PSU.
And I don't know that. And I don't know how far you're going, and that's why I'm asking these follow-up questions.
Yes. And in light of the potential for officer discipline, that's why it needs to stay in the purview of PSU as opposed to us saying, okay, we're going to do an investigation and reach a separate conclusion. Yeah, and these are all kinds of issues that we're transitioning to as we move to the community commitment and all of that. So, it's kind of fresh for all of us.
Yes.
So I have a question regarding SOP 5.1.12, which is associations with persons of questionable character. I haven't looked at that SOP, but I assume that someone with a felony conviction or a pending felony charge would fall into the category of a person of questionable character. So I don't know does that SOP refer to an officer having actual knowledge of the person's questionable character, or is ignorance, reasonable ignorance, a defense?
No, reasonable ignorance is not a defense, and thus
So how is a law enforcement officer to know if a person with whom they're in a personal relationship has a felony charge or a felony conviction without someone researching that, and he did it himself on CourtNet, obviously? How's that supposed to work?
Well, I think it's just one of those aspects of your relationship. As your relationship moves on, I think the officer has to disclose certain things to the person with which they're having a relationship. And, is there anything that I need to be concerned about with your background? I know it presents these kind of awkward situations, but also with all of the resources that we now have with social media and everything else. I think if you're diligent about your relationship and as long as you're not burying your head in the sand and ignoring red flags, I think the officer is fine. But if you're picking your date up from federal court, it might raise a red flag. Now, I'm not saying that that's what happened in this situation.
Okay, but that's certainly much different in my mind, as Scott's pointing out, than the 32 calls that were in the PSU file that occurred. I mean, one, I forgot what the percentage of, I used to have these number of the people who have 50% of the people we encounter, I'm sorry, 1 in 4 of the people we encounter has some criminal record. And an officer's not going to know. A former prosecutor's not going to know. We probably should, and prudence would dictate if something comes up, you ask the follow-up question. But we're human and we make mistakes. And I kind of personally give a pass on that, where the 32 calls not noted causes me to gasp.
I think that that policy is kind of a vestige of old policies, which kind of just sort of survive, you know. That's there. Anyway, I think there is a policy that addresses specifically relationships with those that are felons and known felons, and so, yeah.
Motion to approve?
Approved.
So moved.
All those in favor?
Aye.
All those opposed? Thanks, Ed.
Next, we have a cavalcade of responses from Chief Humphrey regarding recommendations that have been made over the past few months. I think instead of going through each one of them individually, although I can probably, actually, Dr. Whetstone did a nice one-line encapsulation of the response. If you want, I can go through those. We have questions probably on 2 of them. And the chief's responses has had us contemplate an operational change within our office as well. So first, the operational change. We're no longer going to simply send a recommendation for a PSU to the chief, for the chief to use his discretion whether or not to do a PSU investigation. Because the community commitment requires that any formal complaint that comes to PSU must be investigated, that's what we will send over, whether we do it as a third party or whether we do it with the original complainant, drafting the affidavit with the complainant and then sending it over to PSU so that we prevent what we're sending over, we believe, reaches the level of reasonable suspicion which should initiate a PSU investigation just based upon our recommendation. Clearly, the chief doesn't see it that way based upon his responses. So, in response to his responses, this is how we're going to operate moving forward in order to ensure that if we believe a PSU investigation needs to be done, that it be done.
Motion for that, or you're just telling us you're doing that administratively?
Yeah, that's an internal operation for our office as we, navigate these waters. I think that as far as A goes, the MOU for OIG and LMPD policy, the chief said that he would review the policies in the time of the policy review. I think that if we make a policy recommendation, then the chief should act on it, not wait for it to come up in due course of review. That's certainly the standard that I'm used to. If we make a policy recommendation, especially because our policy recommendations are well researched by our analyst, then it should either be enacted or we should be told why it's not going to be enacted. Related to the MOU, the chief doesn't want to act until we're under the community commitment, and the administration says we're not under the community commitment until the monitor has been appointed and signed to the contract. So right now we are operating under the auspices of the community commitment, but we're not actually under the community commitment as yet. Regarding 10 IG 2023, the chief of police does not agree. I'm sorry.
Yeah, I did see there was a pattern to his response with Chief Humphrey waiting until community commitment. What is your guys' plans? Do you feel like you guys are going to put it on pause as in waiting on a response and still like hold him to give us a response to them, or do we need to change it up once the community commitment gets enacted or contract signed?
I think once the community commitment is signed, then we will move forward with the MOU that we've all approved already and sent over to them for its incorporation, or whether or not that's going to be a negotiation. Our first MOU was a negotiation with the chief and the administration and their legal counsel. This will involve, if it's not enacted as we've proposed it, most likely this will involve the monitor and the chief to negotiate that, because this will come under the auspices of the paragraphs that involve us and how we're to conduct our business under the community commitment.
Since you guys have gotten the chief's response, but with this hiatus, so I guess what would you consider the status of these reports since you've gotten the response?
Some of them are final, and there's a couple of them that we think we need to revisit. Yes, these are really the first responses that we've gotten. And so now we're, there's no map for this. And really, there's even a question of procedurally, how do we do this? So do we bring it back to the board? Because the board has to approve a full investigation. So at this point, these that have been sent over have not been approved for a full investigation. So I think we'll have to bring them back to the board if we want to do a full investigation of that particular complaint. So I think in two of these instances, 120 IG-2024 and 150 IG-2025, we believe that those are probably investigations that we will want to bring back to you to authorize a full investigation. But we're doing more follow-up with the complainant first before we bring it back to you, so that we can tailor this to compliance with the ordinance.
The reports and recommendations to which the chief provided responses about a month ago date back to 2022. Do you have an expectation regarding whether or not going forward we will be getting responses from the chief on a more regular basis as opposed to saving them up in 3-year batches and releasing them all at once?
I think the chief is going to be more responsive. I think that, to be fair to him, over the last 2 months he has shown that. And what he pledged was he would respond to those recommendations that were made when after he became chief. He would not respond to anything that went to his predecessors. So he has committed to that, and he's done that. And I was just thinking about this issue literally today. Part of what we're seeing is because there was no entity to which to complain aside from the PSU. We had some of those old cases that were there that people wanted some redress from 2020, 21, 22 that only came to us when we became operational in 2022, 2023. So that's why some of these cases are older. But because now that we've been operational, I think we really will kind of phase out of some of those older cases, and we'll certainly be dealing with more contemporary issues. So it's kind of because we didn't exist before and there was no entity to go to, it's almost like we had a backlog out there of unreported things. And they've come to us, and so I think it'll be much more contemporaneous now.
Do you think there'd be any concerns from the community on the sense of like closing out all those previously held cases and whatnot from your end?
For the cases that we have, I don't think so. We'll put up, we've put up our we'll put up our recommendations and findings. We'll put the chief's responses right next to them so the community can see those. There is no statute of limitations at this point, so if there's a new complaint and it happens to be from an older period of time, if there's information on which to investigate and act, then certainly we'll bring it to you and request a full investigation.
What number of, outstanding cases have not been responded to yet? Like, are these 16 the entire backlog, or are there more out there that you
I don't know, but I'll get the answer for you to see how many other cases we're waiting a response.
Is a response required by the ordinance, or?
It is not required by the ordinance. It is required under the community commitment. It was required under the consent decree. The consent decree said 45 days. So our MOU is asking for reinstatement of that 45-day period because the community commitment says in a reasonable time. So that is one of the issues. The ordinance does not require a response from the chief of police for any recommendation that comes from this entity.
You said you're making your request to have the 45 days established, right?
Yes, in the MOU and I'm sorry, it's prior to you being appointed. So when we became operational, we had to negotiate an MOU for our interaction between our agency, the board, and the department for gathering information. So that MOU went into place, I believe, in March of 2023. But then, once the consent decree was released, we determined that there would be a need for us to change the MOU in order to comply with the consent decree. So we drafted an MOU in order for our operations to comply with the consent decree, modified once the community commitment was signed, bringing some of those standards back. So that's where we've asked for that deadline to be reinstated.
The MOU is available on our website, if that's something you want to read.
Any other questions regarding Chief's responses?
To any specific response, or?
I'm sorry?
To any specific response, or are we about to get into that?
To any specific response?
17 IG 2022.
Okay.
I'm not familiar with the retaliation SOP, so just like right at the very end of it, where obviously they're not allowed to retaliate if people are just making complaints, but then it says any disciplinary action taken against a member for filing a complaint or report in bad faith and or being untruthful shall not be considered retaliation. What does that mean a little bit, I guess? Because the first paragraph is unbiased, complete. You cannot retaliate unless, you can't retaliate, but you can perform disciplinary actions. could disciplinary actions be construed as retaliation? And what is filing an untruthful complaint? What if it's uninformed? And I'm just poking holes in.
Well, what we recommended for, I believe, this particular case was we recommended an expansion of retaliation to include officers being able to freely communicate with our office without fearing retaliation. So I think we don't have the ability to discipline, so there can't be any retaliation based upon anything that we would do related to discipline. The question about false, untruthful complaints, it's one of the aspects that is in the KRS within a complaint from the community, and it is on the affidavit that says that if you file an untruthful affidavit related to a complaint, you can be prosecuted. It's language that is not favorable, but it is there. It has a chilling effect, but I don't know that it's ever been really enforced.
Well, yeah, okay, that's fair. Because I'm concerned when I see that language, and then I think about the previous times when you had major findings and you put recommendations and they went out there, and then Chief Humphrey had colorful language for Investigator Caddy Snow, and then was pointing out that information was untruthful or there was lies, but there was aspects with it that there was limited information you could receive. And I know that's a completely different context, but
yeah, and I think that that opinion expressed in that short term, having not reviewed anything, opinion was misstated, and we will only put forth what we believe is true information with good faith.
I'm there with you. The policy language, which I agree with you, needs to be expanded, because once I read that line, I'm like, well, I don't know. It seems a little too vague, and in this climate, it's interesting to see a policy where we can actually discipline people for doing things in bad faith. Mm-hmm. That's why I was like, oh, carry on.
I have a follow-up. Mm-hmm. Because several of us are members of this board, are lawyers, we hear things out on the street. Some of the things as far as retaliation, I suspect, are involved in the pending litigation. And you don't know, and I don't know the answer to that. But that's what I hear on the street from officers and others alike. When I read this last sentence from Chief Humphrey, LMPD finds the current policy is concise and sufficient. Therefore, the full policy, as it is recommended, will not be adopted by LMPD. His answer just says that it's concise and sufficient. It doesn't give us reasons why he thinks it is sufficient. And then I guess I wrote these down as I was reading this. What are the examples of or complaints of retaliation? Because they're not mentioned and they're not talked about. What are the results of their investigation of these allegations, these events, or these findings? Who did that investigation? Is it Mr. Wampler? Is it his department? How thorough, by whom, what was the process, and who were they reported to, and what were the actions contemplated, and then the actions taken as a result of the findings that we don't know about. And I guess I find that a little troubling. And I don't mean to be making a statement other than, boy, that was a curt and short way to answer what was really a rather complex issue. And I guess I was disappointed in that.
We too are disappointed that the chief chose not to adopt our retaliation policy in full, because we've recommended it twice, and the second instance was in response to the chief and the mayor's statements, public statements, that their officers, because this was in the context of civil litigation regarding sexual misconduct, their officers should feel free to come forward to our office if they were having issues. So therefore, we reintroduced the retaliation policy.
I guess as a citizen of this community, I'm going to be really disappointed if these things have been going on within that department. And this is the response the chief sent to basically an oversight committee. I mean, that's concerning to me. And I just have, there's so little meat on these bones as to the reasoning. I just find it troubling as a member of this committee.
Are we able to go back when those responses, for example, we need more information from him versus just giving us those short statements? Can we go back?
I don't think anything is off the table, so if you wanted to request further explanation, I mean, I don't see anything that would prevent it.
I'm going to make a very general statement. There are some exceptions for sure, but I'll have to say that overall, I was encouraged by the responses in their substance and thoroughness in addressing the concerns that were raised in the reports to which the chief was responding. I don't mean to suggest I think that they are entirely adequate, but I'm just telling you that overall, I was encouraged. I think that he could have done a lot less in terms of effort and so forth in doing the responses. So, yes, there are some particular ones, no question. I think, I do have concerns, some of which have been expressed here in this meeting, but in the big picture, I'm encouraged by the body as a whole of these responses. It's just my personal opinion.
Oh, I think it's fair to say that we've come a long way from complete absence and ignoring anything that the board did. So, absolutely. So, despite frustrations, these are actually positive steps.
I just want to say, Scott, you're not wrong. I don't disagree with that.
I know I'm not wrong. You're not either.
And you're seeing two perspectives.
We have to approve these, or we're just being informed?
These are just for your
Okay.
information.
Good. Okay.
And if there's something that we want to bring back to you, we will bring it back to you on a separate agenda for your consideration.
All humor aside, Scott, I agree with you. There are certain responses I didn't write a thing.
Yeah.
Because they were direct, they were informative. I think there's, well, and I don't know how to say this. There has been problems between the chief and this body, including bit, and I hope it improves. And if you're saying, Benham, you haven't been on here long enough to see where we were and where we are now, I totally accept that and believe that's probably true. But as a new member who's had some concerns, I just wish it was handled maybe a little bit better.
I understand that, and I actually share your very concerns. I just wanted to make the point that I think this is progress.
And thank you for telling me that,
Yeah.
because I wouldn't have known that. Okay.
Any other question regarding chief's responses? Okay. Then, unless there's other business.
I have one item for other business, so I just wanted to ask for an update from our chair. So at the August meeting, within a day or two, our chair sent an email to the mayor in accordance with the ordinance that created this, that governs us, asking him when and how he would like to consult with this board regarding the question of Inspector General Harness's reappointment. And I believe after the passage of a couple of weeks, not hearing anything, our chair sent a follow-up email seeking communication about that issue. And I just wanted to ask our chair today whether he has heard any response from the mayor or the mayor's office.
As I refresh my email inbox, no.
Okay. So that raises the question regarding whether what, if anything, we can or should do to press that. I mean, you can send endless emails, but not having gotten a response to two, do we have other options to work towards having that required consultation with the mayor?
Don't have any solutions, but the next meeting I have today is also with his executive assistant, so I'm just going to ask her if she can give me a candid response or just mention that's what's on our mind. And I'll see if he's aware.
And when is that meeting?
5:30.
Okay.
Okay.
If that is all, I can call a motion to adjourn. Do we have to approve that? Okay, well, thank you. Thank you, media news outlet people, for joining us. And thank you, OIG staff and office, for everything you guys are doing. I would like to note for the next meeting.